How does the entire process work of bringing my fiance to the United States and getting them a green card? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. Today's question comes from Sri, and Sri is a U.S. citizen, and Sri has a fiance back home in India that Sri wants to bring to the United States. And Sri's wondering, how does that process work? So let me walk you through it. So only U.S. citizens can sponsor their fiancés. Lawful permanent residents, green card holders are not allowed to sponsor fiancés to come to the United States. So luckily, Sri's already a citizen, and that takes care of one big hurdle. And so the process works by filing a form called an I-129F, paying the filing fee, and submitting documentation of the relationship. And so USCIS has been taking about 5 or 6 or 7 months to approve I-129Fs lately. And the things you need to put in there are sort of important. Obviously, you have to submit all the right forms, and then you're going to want to submit some particular evidence. One piece of evidence is that you're going to have to show that you've been in each other's physical presence in the last 2 years. That is, that at some point in the last 2 years, you've met face-to-face. You cannot file a fiance visa if you have not met your spouse face-to-face. That's something that surprises people sometimes when they come to see us. And part of our job as the immigration lawyer is to prove that. We're going to have to develop evidence like your travel receipts, your plane tickets, photos, phone calls, emails, anything related to the trip itself. If you want to see shows or tickets for anything, if you took train rides or if you met with family, you're going to want to provide proof of all of that because you have to sort of convince the immigration service that you have in fact met face-to-face. That's one thing. Another thing besides the forms that you're going to have to submit is a statement that you and your fiance intend to marry within 90 days of arrival. So typically what we do is we have a simple statement from the U.S. citizen and a simple statement from the foreign national, and it basically says who I am, how I met my fiance, sort of tell a little bit of the story, talk about the last time that you met face-to-face because that's also good evidence of those 2 years physical presence requirement that I just talked about, and then a clear statement in the affidavit or the statement that you and your fiance intend to marry within 90 days of the foreign national's arrival in the U.S. So you send all that off to the Immigration Service, and that goes to the USCIS, to the right service center. And then once that's approved, like I said, 5, 6, 7 months later, then your case is sent for processing at the embassy. At this stage, you have to file an electronic form with the Department of State. So you're switching from one agency to another. At this point, you're switching from the U.S. Citizenship and Immigration Service, which approves the fiancé petition and then sends it on to the State Department for processing at the embassy. And during that stage, you're going to file a form called the DS-160. And this is an electronic form that you'll fill out, and it has a lot of the same information that was already asked in the I-129F. But like I said, you're dealing with a different agency, so you have to outline all that same evidence and same information again. There might be a little bit more about criminal history of the foreign national. We have seen more and more questions added to the DS-160, so it does take a little bit of doing, and then we have to submit evidence in the form of a checklist to the Immigration Service to get everything to the embassy. And then once it gets to the embassy, each embassy does things a little bit differently. It depends which embassy you're dealing with. Some are very organized and methodical, some are very laid back and loosey-goosey. And so one good thing about working with our firm or other experienced immigration firms is that we've sort of developed a list of the things that each embassy that we've dealt with before has asked for, the little nuances or the little unusual things about that particular embassy, and so that's really helpful. Eventually, you're going to pay that fee for the non-immigrant fiance visa, and then once the person comes, they're going to be issued a K-1 visa, and they're going to be allowed to enter in the United States. Once the foreign national is here, and you, the U.S. citizen, marry the foreign national, then at that point, you're going to file for adjustment of status. You're going to file an I-485 application to adjust status, and you're also going to file for a travel document and work card because those adjustment cases are taking a really long time, and you might want to have the ability to be able to leave the United States or work in the United States while you're waiting for that green card to issue. In the past, there weren't many interviews on these standalone green card cases where the embassy has already approved the person to come, but we've been seeing more and more that USCIS, which is the agency that actually handles the green card, is scheduling more of these for interviews. So you might get an interview on that, and you and your spouse are at that point going to have to show that it's a valid marriage and demonstrate the relationship. So that's sort of the whole process from start to finish. That's how you get the green card for the foreign national through the fiance process. Right now, through a strange quirk in the way things are working, fiancés are coming to the United States more quickly than spouses. So if you have not already gotten married, that is probably an option that you want to discuss with an experienced immigration lawyer. One thing you don't want to do is what a client of ours recently did, and that is to pretend that they had a fiance case. At least that's what USCIS thought. USCIS thought that they were actually already married. So one thing that you have to be careful about is not actually filing for a fiance case when you're in fact a spouse. And some people try to do that, or are alleged to try to do that, because they think their spouse/fiance is going to get here faster. So basically, if the relationship has been consummated and a ceremony has been held in which it was recorded with the local government, for the most part, you're going to be considered married. And if you try to come as a fiance, that's most likely going to get denied. We hope you found this video helpful. We hope you like our videos. If you do, make sure to sign up and subscribe to either our YouTube or Facebook channel. Make sure that you share the video with your friends. And if you have any questions or emails about this, or suggestions on other videos that you'd like for us to do, you can either record it at immigrationanswersshow.com, or you can email us at info@hackinglawpractice.com. You can also always give us a call to schedule a consult if you like, 314-961-8200. Thanks a lot, and we hope you find this helpful. Bye-bye.